All right. Then do we have Mr. Mula here? Excellent. This is case number 25M1510. I understand, Mr. Sullivan, that your office might have a conflict with this case?
Yes, Judge, and I believe it was filed with the court.
Okay. So let me unmute Mr. Mula. So good afternoon, Mr. Mula. This is Mr. Sullivan. He's here with the Office of the Public Defender.
Yes.
They have a conflict with your case, so if you remain in custody, I'm going to appoint a lawyer to represent you.
I represent myself, ma'am.
Okay.
It's a right. So
Sure.
I represent myself. Yeah.
Thank you. I don't need you to advise me of the law, sir. But if you'd like to exercise your Sixth Amendment right to represent yourself, you may. Let me hear the people's bond argument, and then if you'd like to make an argument, you may. I'm going to mute you while they do that. Thank you. Ms. Mayfield, what is your argument regarding bond?
Your Honor, I don't think I have an argument under 164113.
So I'm not sure if you do you know what happened yesterday?
Maybe not.
So, yesterday, Mr. Mula appeared in Division 7 and was extraordinarily disruptive, using very foul and offensive language, very obstructionist behavior in the courtroom, failing to adhere to court orders, to appear at the lectern, essentially failing to adequately identify himself. What I'm going to do is allow you to make any argument you'd like to make, Mr. Mula, and then I'll make a ruling regarding bond.
Yes, ma'am. I was illegally detained on a bench warrant that was issued while I was in a courtroom for a non-appearance. So, yes, I got irritated. I know my rights, ma'am, and I have the right to travel in regards to the first trespass charge. So also I work with the homeless community here.
Okay.
I work with all the programs.
Okay, if you could wait just a sec. What I'm going to do is ask you questions under the statute. I'm going to ask you questions under each subsection. Don't talk about the allegations, okay? So what is your full name and date of birth?
I'm Johnny Lay, free and living man, all rights reserved.
Before we even get into the courtroom, you need to understand what you're about to watch here, because this isn't just another legal hearing. This is a pattern, a cycle, a repeated collision between sovereign citizen ideology and the actual functioning legal system. And every time it happens, the outcome is almost identical, yet somehow the confidence of the individuals involved never changes. What makes these cases so gripping isn't just the law itself. It's the absolute disconnect between belief and reality.
If the court were to release you on a personal recognizance bond, would you sign that bond?
Yes, ma'am.
Okay. Let's see. What are your ties to the jurisdiction?
To the jurisdiction.
To Boulder
I've
County.
been here for 2 years, seeking sanctuary, and I've been bullied and targeted and harassed by cops and other organizations since I've been here for helping the homeless.
Okay. And just wait. Ms. Mayfield, you said you don't know of any record you could make under E or F.
I do not.
Okay. All right. Mr. Mula, was there anything else that you wish for me to know before I address your bond?
Nope.
All right. Okay. What the court is going to do is authorize a $1,000 co-signed personal recognizance bond, no contact with the victim, pretrial supervision.
And who's the victim?
Let me take a look.
And what are the charges? I didn't hear any charges. So.
Yep. So let me tell you, you were, I think, issued a summons, but let me take a look. Yes, you were. And so when you were issued the summons, the
I don't have an address.
just a sec.
I live in a car.
Somebody likely handed it to you, but let me take a look. And how about we do this? I don't interrupt you and you don't interrupt me.
Sure.
All right.
Thank you.
You're welcome. Yep, it looks like the officer tried to hand you the summons, but you refused it. So let me share with you what the charges are. You're charged with the unclassified petty offense of third-degree trespass and the Class 2 misdemeanor of obstructing a peace officer. As it relates to the address you are alleged to have trespassed.
Kevin G. Fine.
Well, do you see that, Ms. Mayfield? That it's Evan G. Fine? Oh, here, oh, yep, it is. So when I say no contact with the victim, it's Evan G. Fine.
Okay.
Okay? You asked me what that was. So now, let me tell you,
Can I ask a question when you're done here?
you may ask that question right now if you would like.
How is a public space a victim?
So you are trespassed from that area, and so what I'm saying to you is no contact with Evan G. Fine Park.
Well, the officer that I had initially interacted with said that it was only during the hours of 11 to.
Right from the start, you can feel the structured environment of the courtroom trying to establish order. Case numbers, legal representation, procedural acknowledgments, all of it is routine for the court. But what makes this situation interesting is how quickly routine starts to clash with resistance. The judge is doing exactly what a judge is supposed to do, ensuring representation, clarifying conflicts, and moving the case forward. But the moment a defendant begins rejecting legal counsel or refusing standard procedure, the entire system has to slow down and recalibrate.
This is 25 CR 3889. Mr. Gavin appears out of custody here for a first appearance. There is one formal charge that's been filed. And Mr. Slocum, do you have a copy of that complaint information?
And I'm sorry, was this Mr. Gavin?
Yes.
Okay.
And so this is a copy of the complaint information. So hang on to that. It has some limited information about the charge that was filed and your case number. Mr. Gavin, are you planning on applying for the public defender's office?
No, ma'am.
Okay, you're planning on hiring a private attorney?
No, ma'am.
Okay, you're just going to represent yourself?
Yes, ma'am.
Okay.
Okay.
All right. Well, Mr. Gavin, do you have any legal training?
No.
Okay. Have you ever filed a motion for, have you ever had a motions hearing?
I'm not illiterate, Your Honor.
I'm certainly not implying you're illiterate.
I feel. So can we please approach?
Okay. No. So my concern is that you want to represent yourself, and it's not that I'm implying you're not intelligent. What I'm trying to just advise you of is that the legal system is really hard to navigate and it's very complicated.
Your Honor, I understand, but that has nothing to do with me, Your Honor.
This is one of those classic sovereign citizen moments where language itself becomes the battleground. Phrases like living man, all rights reserved, and similar declarations are used as if they carry legal force inside a courtroom. But here's the reality. Courts don't operate on self-declared identity systems. You cannot redefine your legal status through phrasing alone. What's happening here is more psychological than legal. The attempt to assert control in an environment where control has already been legally defined. And what makes it even more striking is the repetition.
All right, I'm going to give you an advisement here. It's called an Arguello advisement, and it's required for individuals that want to go forward pro se and represent themselves. I want you to know that you have the right to counsel. You can hire a private attorney, apply for the public defender services and see if you qualify, and then one would be appointed at no cost to you. Do you understand that you have the right to be represented in this proceeding?
Your Honor, is there a bond on this?
Sir, if we can't get through an Arguello advisement, then I can't continue your case. So we're either going to get through this advisement or I'm just going to keep setting you over until we do. So what would you like to do? Go through the advisement so that you can then represent yourself and your case can move forward?
Your Honor, is there a bond on this case?
You're out of custody, so you've posted a bond if there was one.
Is there a social security on this case?
I don't know what that means. A social security what?
My social security number.
Yes, your social security number is associated with you in this case.
Right, so it's tied to all my charges, correct?
Your social security number?
Yes.
If it's associated with you and you're associated with this case, then I would assume it's a part of.
So I am the beneficiary, correct? And you are the fiduciary. You are the servant of the state.
At this stage, the courtroom shifts from identity disputes into actual legal consequences, bond conditions, restrictions, and enforcement. And this is where reality becomes harder to avoid. When the judge outlines no contact orders and bond requirements, it's not a suggestion. It's a structured legal framework designed to ensure compliance and public safety. But what often happens in these moments is a disconnect between what is being explained and what is being processed by the defendant.
So, Mr. Gavin, you have an active warrant in another case in 21 CR 5803. There was a failure to comply warrant that was issued on September 5th. And there's a no bond hold. So you're gonna be remanded and go into custody on that case. And what we could,
September 5th, I was in custody.
that's when the warrant was issued.
I was
For-
in custody, ma'am.
That very well may be. So the warrant was issued on September 5th, advising that you failed to comply in 21 CR 5803. Having an attorney would certainly help you understand everything that's going on. Either way, you're going to be remanded on that case. And then this case is going to,
The bailiff can't touch me. That's illegal for the bailiff to touch me. You're a servant. You're a deputy sheriff, either or. You're not allowed to touch me.
That's not how this works.
How is there a warrant? How is there a warrant for someone in custody?
so I think what I'm going to do with,
This segment highlights one of the most critical choices in any courtroom: self-representation. The judge is not discouraging it out of convenience, but out of practicality. Legal systems are extremely complex. Procedural law, evidentiary standards, filing requirements, and case law all interact simultaneously. When someone chooses to represent themselves without training, they are not just arguing facts. They are responsible for navigating the entire legal structure alone. And what stands out here is the resistance to advisement.
this case, I haven't gotten through an Arguello advisement, but I tried and it doesn't seem like we're going to get there. So I'm just going to send it to Division 8. We'll set it for an arraignment there. We'll make a note that Mr. Gavin is wanting to represent himself, and that he still needs an Arguello advisement, and Mr. Judge Bentley can work on that. And then Mr. Gavin will be remanded on 21 CR 5803 in that court.
I'm not going to be remanded for something I didn't do. I was already in custody.
It doesn't matter.
It does matter. How do I get another charge if I'm bound?
Attorney, and if you were
I
willing to
bonded.
listen, I could explain this
I
to you, but
bonded
you're
out, Your
not,
Honor.
so I can't.
Your
explain
Honor,
it
I
to you
bonded out.
on this case.
Yes, there was
I'm
no other
talking about
case.
a different case.
How do I have another case if I'm already in jail?
It's 21 CR 5803.
25, excuse me?
21 CR 5803.
And what is this under?
This is a
What are the charges?
probation case. So that's the case you're on probation for.
I'm on probation on all the cases.
This is where the conversation takes a sharp turn into sovereign citizen financial and identity theories, specifically the idea of beneficiary versus fiduciary relationships with the state. Legally speaking, this interpretation is not recognized in any court framework. Social security numbers, case records, and identity systems are administrative tools, not indicators of ownership or trust-based legal relationships in the way being described here. What's happening instead is a reinterpretation of administrative language into a completely separate belief structure. And the court, understandably, does not operate within that framework.
I'm already on probation, Your Honor.
Not in this new case. This is your old case that you're on probation for.
But I was already in custody.
I understand that on this case, and you bonded out on this
I
case.
bonded out.
And then there was a warrant issued on your.
How was there a warrant?
Because there was a failure to comply based on this new case. When you're on probation, it's a violation of your probation to get charged with new cases.
Okay, so what is this
Great.
number again, please?
Mr. Gavin.
Can I get this case number?
She said you got it.
I'm trying to write down this case number.
Sorry, I've given it to you multiple times. I can't help that you're not listening to
We
me.
got it over there. Okay.
I'm just trying to put this, man.
Yeah, I'll grab that.
Damn it, every time I come up here, y'all trying to put me in here, man. I'm tired of you, Honor, too. You're just a servant here.
Don't resist, man.
I'm not resisting.
You are resisting.
Man, you trying to hit me on a pin cap,
Don't
dog.
resist. Put your hands behind your back.
I have my hands behind my back. If you guys are over
Right
and
there.
react, that's fine. Because I can slam all y'all.
Stop resisting.
I'm not resisting.
You are.
How am I resisting, Martinez?
I don't know who Martinez is, but it's only.
Well, don't know. I'm not resisting. Just bond it out. See, I'll try to play the game and bond out to take people's money, right?
You're on the cricket, let's do it. All right. All right.
Are my things still
Yeah,
have my,
we'll grab your things.
I have my information, correct? Public servants shouldn't be able to do this. Citizen that's solid.
Now, how are we gonna?
This is the breaking point. Everything prior, arguments, objections, legal confusion, all converges into direct enforcement. When court proceedings escalate to physical custody, it means procedural thresholds have been crossed. Compliance has failed, orders are not being followed, and the legal system transitions from discussion to enforcement. What stands out here is the emotional escalation. Once reality fully sets in, resistance often shifts from verbal arguments to physical noncompliance, which immediately changes the nature of the situation from courtroom dialogue to law enforcement action.